this printer. Let me mute so you don't have to listen.
All right, everybody. I want to welcome you to our monthly edition of Work Comp Today. I'm Bernard Nomberg with the Nomberg Law Firm in Birmingham. And Brother Dave is not going to be with us today. He's busy traveling, and we don't want him to be online and try to travel at the same time. But that's okay. We more than will make up with it with our guest today, Malcolm Crosland with the Steinberg firm out of South Carolina. Welcome, Malcolm. We really appreciate you making some time for us today.
Well, thank you very much for inviting me. It's a pleasure. And
I think we lost Malcolm's feed. Hopefully he'll come back with us in just a second. Well, while we're waiting for him to sign back in, I'm not sure what happened there. If you guys know, this is our show that we do each month that involves employers, employees, and independent contractors. It's the news of the month that impacts our practice. It's the type of practice that we do at the Nomberg Law Firm in Birmingham. It's also the type of practice that Malcolm handles at the Steinberg firm throughout South Carolina. And the reason why I brought on Malcolm, and he'll tell more about the organization in just a minute, Malcolm is currently the president of the Workers' Injury Law and Advocacy Group, WILG. It's a national organization that we'll get Malcolm to tell us a little bit more about. But Malcolm he's at the top of the food chain, so to speak, of over 1,000 practitioners throughout our state. And usually our guests come from members of that organization. And here he's coming back now with us, so that's good. No, he lost his feed. Hopefully he'll come back in just a second and we'll get this straight. We'll keep going. But what we're going to do, as we do each month, we're going to spend about 30, 45 minutes talking about the current articles and news that impacts employers, employees, and independent contractors. Hopefully there's not a lot of pandemic related news out there, but we're going to still have it every month. But we've got some other topics that have come up that impact our world and Malcolm's world of representing injured workers in all different types of scenarios. And so we want to share what's going on in those areas. We want folks to be informed. And now we got Malcolm back with us. Malcolm, I did a brief intro of WILG and that you're the current president of an organization of 1,000 strong practitioners around the country. But I want you to share just a little bit about what WILG stands for and its impact, how it helps those who are in need around the country.
well, thanks, Bernard. Yeah, WILG is a organization exclusively of workers' compensation claimants workers. But beyond that, also we have a section of within WILG that consists of lawyers representing injured federal workers, FECA, Federal Employees Compensation Act, which is a separate animal altogether that I don't handle, but I am sure glad, and there are thousands of federal workers that are glad we do have members who do handle those cases. We have a longshore section, those members that practice almost exclusively. Some of them are practiced both in state and before the Department of Labor. And we also have various sections within WILG that are sort of specialized, that work on sort of law practice related issues, such as the high-tech Records Act. We have an AMA guides section. We have a immigration section. We've got various sections that sort of deal with subspecialties that affect injured workers. And so that's really primarily, Bernard, what WILG is here for. It is an organization of claimants lawyers working in various fields within the umbrella of work-related injuries. And it's, as you said, about 1,000 members from every state in the country. So that's kind of what we do. And our goal is to advance both legislatively and professionally the cause of workers' rights in general, and especially those workers injured on the job.
It truly is a brotherhood and sisterhood of practitioners around the country and all over the place. Brother David and I, David's been a member for a number of years, and I joined a few years ago. And even though there are not that many practitioners from our state, from Alabama, who are part of the organization, we've made friends from all over the country. And it's referral business, it's sharing ideas, and just the camaraderie is very special. And this weekend, we've got the annual convention that's going to be in Florida. That should be just another opportunity for sharing such and brotherhood, et cetera. So thank you, Malcolm, for your continued leadership, and we really look forward to sharing some time with you this weekend.
I look forward to it too. I always like spending time with both you and your brother.
And it's okay. You don't have to say it. We are recording. We're not going to ask you to choose which brother you prefer, but we'll jump into the articles for this month. Right.
I love you both the same as long as Alabama's not playing South Carolina.
Well, I don't know. Are they on the schedule this year? I can't remember.
That's why we're going to get along just fine.
That's right. That's right. Well, this first article for this month comes out of the state of Kentucky. And the article is Kentucky Supreme Court says statute terminating income benefits at age 70 is constitutional. And Malcolm, I know that Kentucky's not the only state, but it hasn't yet impacted our state in Alabama. What do you say? What's going on in South Carolina, and what do you think about this?
Well, I'll take the last question first. I am glad that you put this on the agenda for today, Bernard, because I really thought this was a very disturbing and troubling decision and disappointing decision. I was interviewed by a reporter from Work Comp Central on when the decision came out, and I didn't mince words in my comments. I think it's just one of the worst decisions that I have read in quite some time. But that said, like a lot of bad decisions from the courts, they start with bad law. And the court was relying on their interpretation, as I recall, of the Kentucky statute, which provides that, that there is a reduction. And in fact, I guess the initial version was declared unconstitutional. They went back to the drawing board, the legislature did, and tweaked it. And apparently the tweaking has satisfied at least the Court of Appeals. I think this was a Court of Appeals decision as opposed to Kentucky Supreme Court decision. So it was really troublesome. And in South Carolina, to answer the second part of your question, we don't have such a statute. There is no reduction. You collect your full Social Security benefits and without reduction to your workers' compensation benefits. But I really do find it difficult to rationalize this opinion and to understand it in any other way other than it is clearly discriminatory based on age. An injured worker who is 65 years old and sustains the same injury that the 70-year-old sustains, his Social Security benefits are intact and the 70-year-old's is not. I don't understand the court's rationale that there was any state interest to protect whatsoever. And I further object to the notion that somehow or another, the Social Security benefits being received by the injured worker are somehow the way that the court almost behaves in this opinion, that the state has an interest because they are receiving Social Security disability benefits or even retirement benefits. Those are benefits the injured worker paid for. It's his or her money.
Yeah.
So to then trim it down or reduce benefits based on that just is nonsensical to me and punitive. I don't understand the reason.
With the working class getting older and older and more people being more fit to work and wanting to work, I think that this is only going to become more and more of a headache, because if older people are working just by sheer the fact that they're working, there's going to be more and more people impacted by this. And the one thing that I did want to bring up, the new statute now limits the duration of benefits by linking cessation for all income beneficiaries to the latter of two events: reaching the age of 70 or 4 years after injury or last injurious exposure. And we don't have that part of our act, at least not now. I know they've been fighting it. The folks on our side of the bar have been fighting this for years. But it is troubling with more and more older people working. It's only going to become, it's not going away, I guess is my point.
No, it's not going away. I agree with you. It is only going to tend to affect more injured workers as the front end of the baby boom generation starts to retire, as you've alluded to. It's going to affect them more and more. And again, it simply is a windfall that is undeserved and unneeded. I just, quite frankly, I just don't understand what's next. I have to wonder. If I buy a private disability policy or annuity that kicks in when I retire, are my benefits to be reduced because I've got a workers' compensation claim? I really don't quite. Again, there's a disconnect here that the court, I thought, did not do a terribly convincing job of explaining what the state interest was that was so compelling to uphold this opinion.
Well, we may see this article or this issue come back around in the future, but we can retire this article and move to our next one. Let's see, this one comes out of Florida, which so many of these do, these articles.
Yeah.
COVID-19 workers' comp claims mount, losses vague. And then the subtitle, Florida is one of a handful of states that hasn't authorized a catastrophe fund for work comp. It seems like I've talked to many Florida practitioners, and the impression I get from their perspective is Florida's going to do what Florida's going to do. And there doesn't seem to be a lot of rhyme or reason or help for injured workers. Is there anything that practitioners or folks from Florida who get hurt that this article really helps at all?
Not that I see. I mean, I don't know what the fund is that you made reference to. I think that the health of the workers' comp insurance industry is very robust at this time, and COVID, as a practical matter and as a reality, really is having little to no effect on premium. In the state of Florida, you've got COVID claims that have waxed and waned depending upon shutdowns or non-shutdowns, depending upon the rollout of the vaccine. But they really, at the end of the day, have not had much of an impact, if any, on premium. So there is no real crisis in Florida. NCCI would validate that. No crisis in terms of the effect of COVID on the system. I can share with you this, Bernard, that there are two factors in play when it comes to COVID. One is that within the field of workers' compensation insurance, that line, there has been, since the initiation of the pandemic, there's been a dramatic decrease in claims because people haven't been working.
Yeah.
When the economy loses 20 million jobs, that's going to bring down claims. People are not working. If they're not working, they can't get hurt. But what we have seen is that within the spheres of the economy that have not shut down during the pandemic, that are most readily affected by the COVID epidemic, those areas of the economy, such as obviously healthcare, first responders, the restaurant, food and bev industry, obviously the industries where you have a lot of human-to-human contact, They have sustained the brunt of the COVID impact and epidemic. And it's there that we look for the most COVID claims. So while claims overall are down because of the economic impact of COVID, yes, COVID claims have been hitting specific sectors of the economy. But what's really important to know is what we as lawyers intuitively now know about COVID, and I think the general public does as well, that COVID claims are simply not expensive claims. Generally, 9 times out of 10, thankfully, the individual is out of work for 2 or 3 weeks, is sore, has a terrible flu situation, recovers, goes back to work, and there's no permanency. COVID is not the plague, but it is serious. And I don't mean by my comments to diminish the seriousness of it, but only 2%, Bernard, just 2% of all COVID workers' compensation claims cost the system more than $10,000. 90% of all claims, in fact, 95% of all COVID claims cost no more than $5,000. Very little in medical, and most of it is indemnity.
And that's less expensive than an emergency room visit or a minor injury that is a traditional work comp claim. I know, Malcolm, probably like your firm, just like ours, we've fielded hundreds of phone calls in the last 18 months about COVID-related potential claims. And at least for us, I can count on one hand how many we've actually taken and
right.
to pursue because of the way the laws are written. And at least in Alabama, they have not been amended or had carved exceptions to allow certain segments of the working world to have valid work comp claim presumptions put into place. Has South Carolina been progressive and done anything like that?
No, South Carolina, like Alabama, Georgia, Mississippi, the Deep South has not been progressive, has been reactionary, and has, because of Republican-dominated state legislatures, has not been proactive in pushing an agenda that would, in my judgment, and I think in most public health folks' judgment, would have brought this pandemic to heel a lot sooner. It has unfortunately become very politicized here in South Carolina, as I know it has in Alabama.
So probably most states.
Yeah. Well, the New England states, I don't think it's quite so bad, and maybe there are a few out there that are being a little more rational about what this is, which is a public health crisis.
It is what it is, and we're trying to work through it and just to educate the public and the folks who are just looking for answers. And that's why we do our show each month. Guys, I've got Malcolm Crosland with the Steinberg firm out of South Carolina. Malcolm is the current president of the Workers' Injury Law and Advocacy Group, WILG. It's a national organization of practitioners, about 1,000 strong. And this is the kind of work that most practitioners in this organization do. And we're pleased to have Malcolm for a little bit for this month's show. Unfortunately, Brother Dave is traveling today, but that's okay. He'll catch us on the replay. We're going to move, Malcolm, to our third article of the month. And this one is coming out of California, which always has some interesting articles. And it is a business owner. And unfortunately, this gets reported from time to time around the country. A business owner accused of underreporting only about $2.5 million of payroll to avoid work comp. This may be one of the higher situations, higher hiding of payroll that I've seen. And for what folks may not know is premiums can be tied to the amount of compensation paid to on a payroll. And I don't know how often you see this in South Carolina. We see it rarely in Alabama. They're pretty good about policing this. But this Zachary Novo, it seems like he went above and beyond to avoid paying what he was supposed to be. Let's see. Has this been an issue in South Carolina that's come across during your practice?
Well, it has to an extent. I think there's always an underlying segment of the employers that is just not going to follow the law. is not going to report, is not going to purchase coverage. I have to confess, in terms of the coverage issue, buying coverage when they should have bought it and having it in place, it used to be a bigger issue. For whatever reason, I don't encounter it very often anymore. But the payroll fraud is really, just insidious to the system. We as practitioners love nothing better than a healthy, robust workers' compensation insurance industry. We are not anti-capitalists. We work and live in a capitalist system, and we are employers ourselves. Every one of the members of WILG, lawyer members, has a staff. We're all employers. But we all, in order for the system to work, everybody's got to be honest and pay into the system their fair share. So when you see extraordinary fraud like the case you just mentioned in California, it really cheats everybody and causes premium to increase for those honest employers who are correctly reporting their payroll, so that they're paying the appropriate premium based on the classification of workers and the amount of payroll.
And I don't know if business owners appreciate or realize that this can be, in many states, it's a crime.
Yeah.
And it's fraud, and it can come with restitution requirements, and in the rare occasions, maybe even some jail. I don't know the specifics of each state, but a lot of times what we'll see, and we have the access, and I suspect you and many other states do too. You go to the Department of Labor, at least in Alabama, or the Department of Insurance, and there's a searchable database for the companies to see whether or not they're complying, at least what they're reporting. Now, if you have an issue, like if we have a substantial injury case and our client or potential client is telling us, well, he really employs or she really employs more than 5, but they kind of are playing around with the insurance and employment reporting, the Department of Insurance has investigators that will go out and actually look out tax records and documents that employers are supposed to have. Now, whether or not that actually helps our client at the end of the process get insurance coverage that's a whole different argument. But at least the people are out there hopefully enforcing, making employers do the right thing so that employees have coverages that for situations when they have bad injuries. But this guy seemed to take it to the extreme out in California.
And the other thing that's just so unfair about it, Bernard, is when you're not reporting your payroll and therefore you're not being charged the appropriate premium, then that gives you an unfair advantage when, for instance, if you're a contractor, then you are able to bid jobs at a lower rate with respect to your competition who's being honest. So it really is just, unfair on many, many levels. And is not good for the system. So yeah, I know that most states, at a minimum, there are fines involved. If there is active fraud, then there may be criminal liability as well. I don't know the answer to that in South Carolina. I do know that if you're not insured when you should have been insured, there is they have a very active and aggressive reimbursement a unit for our uninsured employers fund, which is the fund that steps into the shoes of what should have been a carrier to pay the claim in the event the employer should have had coverage but did not. But they'll go after those assets for sure.
The one from a practitioner's standpoint, one of the most frustrating things for us, or at least for me, and your experience may be similar, is when you have to tell a severely injured worker, or sometimes even the widow or the widower of someone who's died on the job, that there was no coverage because of whatever the employer put into place or didn't put into place. And there's nothing that you can really do from a legal standpoint to protect their legal rights. And it happens, but it's part of reality. But
It is. It is. Fortunately, as I mentioned, in South Carolina, we have a uninsured employers fund that steps into the shoes of and acts as though they are the carrier, and they pick up the claim if the employer should have had coverage.
Yeah.
The real tragic situations are those employers that coverage was optional. They didn't have enough employees to require coverage, and you have a tragedy, and there's just nothing there.
Yeah. Yeah. Well, let's put that one to bed for now, Malcolm. Let's move on to our fourth article, the one that comes out of Connecticut. Workers' comp cases fell in the pandemic, but that doesn't mean employees working from home had no aches and pains. And I really resonated with this article. David and I have put on a couple of seminars in the last year on this very issue. And Dave did some extensive research and only found about 20 or so reported cases about telecommuting, people working from home and being injured, and over the last 20 years of reported cases. Now, there's obviously hundreds and hundreds of situations, but there are scenarios where we've handled some cases in the past year, people working from home, and the approach that you have to look at it, it's as if you take your office from your brick and mortar location and move it physically into your house, and that's your dedicated office. And there are even cases where somebody's tripped over their dog, and that's been a compensable case. Have you guys handled any telecommuting or remote working cases or viewed those in this past year?
Not in this past year. I don't know of anybody that, again, I've got 10 lawyers handling workers' comp cases here in my firm, so I don't know everybody's caseload or the specific facts, but I have not heard of anybody working from home having a claim. We did handle one. In fact, it was probably one of the ones, if your brother did thorough research, one of the ones he would have found would have been a South Carolina case that one of my partners handled about 35 years ago. Mm-hmm. Involved at work from home. A white collar worker was carrying a file down from a second floor to the first floor of her house, lost her footing, and fell down the stairs. And that was the testimony. That was the only evidence in the record. And the Workers' Compensation Commissioner found her credible, and it was deemed compensable.
Yeah, Malcolm, he said from the research, it usually involves ice, stairs, or pets. Those seem to be the three categories, and not all of them, of course, are compensable, but there have been several fact-specific scenarios. But going to this article, it really starts to address that, because, and you may have statistics better than I, but such a large percentage of our workforce in the United States has shifted to either full-time working remotely at home or wherever it may be, or at least part-time. And we've been doing that at our firm for a few years. I'm sure you guys have as well. And you've just, at least I know in my house, I have a dedicated office space, but my dogs are going to be wherever room I'm in.
That's right.
And gosh, I don't want to ever trip over those guys, but it's inevitable. They're going to find you somehow.
Yeah, I know. They know exactly where you are at all times. Yeah, it is going to become more and more the norm for people to be working from home now, especially obviously in more white collar office type jobs. There was a Wall Street Journal article several weeks ago and a New York Times article that talked about this very trend that employers are figuring out. Well, do we really need brick and mortar office space? And what's going to be interesting is almost inevitably those injuries that arise out of work at home are going to be much like the one that I related to you a minute ago. They're going to be unwitnessed, and so the only real evidence in the record, if it goes to a hearing, is going to be the testimony of the claimant that this is what happened and this is what I was doing. So it's going to be interesting to see how that develops. But yeah, they are as compensable as though they happened at the office.
And it's you just hit on a point of something that we stress to our new clients every day. Your credibility is the entire case, because your case is heard in front of a circuit court judge for the most part in Alabama. Alabama's a little different in other states. We don't have a commission, we don't have a tribunal. We're actually in circuit court. We're not in front of a jury, but we're in front of a judge. And if the judge doesn't believe your case or doesn't believe something in your what you're trying to tell them, it doesn't matter how bad your injuries are or how horrible your accident or event was. It's your credibility, because a lot of times, as you said in your that case with the stairs, there may not be any witnesses except a pet or no one. So if they don't believe you, credibility is going to be in question.
Right. But you know, Bernard, the wonderful thing about workers' comp is workers' compensation insurance is social legislation. And the truth of the matter is if judges and commissioners would correctly apply the law as it exists in virtually all 50 states, then sort of the tie, if you will, if there is a tie in terms of whether the claim is compensable or not, should always go to the claimant. It should. You know, it is social legislation to be liberally construed and interpreted in favor of coverage and in favor of compensability. And sadly, we've seen in South Carolina a fairly steady erosion in that notion that, you know, instead of the tie going to the claimant, that more often than not, more and more cases have been decided based on credibility. But when you really start to analyze the credibility, and there's been a very, very helpful, and I would recommend it to any practitioner who sees this tape, a really thoughtful and interesting analysis by our state Supreme Court in a case I can provide you the site later, but as to the difference between deciding a case based on credibility, believability of the witness, versus the character of that witness. And all too often, workers' compensation commissioners, and I presume judges in Alabama, are conflating the two notions and making decisions that they're calling credibility, but are really attacks on the character of the claimant. They may not like the claimant and they may have poor character, but they're truthful. And you got to make that decision.
And that becomes an MO by many insurance attorneys in our cases. They attack our character or our client's character. If they can't attack the facts, if they can't attack the injury or causation, they're going to come after our client. And so we have to continually educate the judges who aren't experienced with work comp that the beneficent purpose of the Alabama Work Comp Act is to benefit the injured worker. That was the grand bargain 100 years ago.
That's right.
And it doesn't always, and I'll get off my soapbox because we're getting away from our article, but it's yet another fight that we have to battle in these disputed comp cases. And unfortunately, it's evolved to that over the decades. But anyway, Malcolm, let's cruise on to our last article of this month. This one is coming, well, this is not really state specific, it's really country or nationwide. And this is probably the article I've been really, really wanting to address. Workers' comp mental health costs, next sleeping giant. In Alabama, if you only have a mental injury, it's not going to be compensable. And that's many states are that way. Some states more progressive. I want to say in Florida last year, they passed it at least for maybe first responders. I can't remember the narrow ruling that it was or the change in the law. But if you don't have a physical injury that accompanies the mental claim that you have, they may provide for medical care, but they're not going to pay you any compensation for what you've gone through, no matter how horrific, if there's no physical. What is South Carolina? How do they approach physical versus mental injury?
Great topic, and probably the most poorly compensated and handled injury of all injuries that we see in workers' comp, and yet so important. But that mirrors how mental health is treated in this country in general. So the answer to your question is that South Carolina is a little bit more progressive, it sounds like, than Alabama, in that we recognize two types of mental injury claims. The what is called the mental, meaning mental stress, causing a mental injury, and also the physical mental, a physical injury causing mental damage or injury or impairment. So either one is compensable. However, in terms of indemnity or benefits paid beyond medical, the injured worker, because a mental injury is non-scheduled, has to show a loss of earning capacity in order to receive an award for any disability, an indemnity award, which again, it kind of cuts out the more minor mental injury cases where the injured worker may have some adjustment problems of some sort, but is able to return back to work and has no wage loss. But if in fact they do have a wage loss, then the claims, and I've handled some that have been, they paid quite a bit of money.
Yeah, South Carolina is much more progressive in that area. Now, what it happens from a practitioner standpoint, let's say we have a very traumatic car accident case, and our client is trapped inside of the vehicle and sustains physical injuries. And from that develops some form of PTSD, anxiety, depression, or some other mental related claims. From a practitioner standpoint, it seems as if once the physical injuries reach maximum improvement, the adjusters and the defense bar takes the approach, well, then the mental should be fine just too. And it rarely goes on the same tracks from a standpoint of when they're going to reach the maximum improvement for the mental as well as the physical. And again, it's a battle that we have all of the time. But from an argumentative standpoint, and from what I hope sometime into the future that our laws will change in Alabama, how can you have a first responder who goes through such trauma, no matter how much training and experience they have, and they go through a just truly traumatic event of losing someone they're trying to save, or a coworker in trauma, a fire, a horrible accident, whatever it is. It breaks my heart. And that's why I do the kind of work that I do. We enjoy representing folks. It kills me that we can't do anything more for them. But I think you're so very right. I think the mental injury part of the claims have got to be the least represented, the least helped of all injuries that we see in a comp claims.
Yeah, I think it's one of the areas of workers' comp law that needs the greatest reform. If you think about it, you mentioned that Alabama's Workers' Comp Act is maybe 100 years old. South Carolina's is not. I think we didn't pass our act until 1936 in the middle of the Depression. But think about what the notion of mental health was like, and the understanding of mental health was back in 1936 or 1926 or even 1966. We've come a long way, and society is much more accepting and understanding, I think, of the significance and the profoundly debilitating nature of mental injuries. The trouble is, you can't see them. Like Ross Perot used to say, you can't pop the hood and look under there and touch it and feel it and see what's wrong. You just got to take the word of the claimant. And again, those types of cases are set up perfectly for the character assassination and the quote credibility attacks that the
in Alabama, our work compact was modernized in the 80s and then recodified in 92. But frankly, I don't think much changed. I mean, you know how bad our weekly comp rate is. It's probably the lowest in the country by far. I'm not going to bring that up today because it seems to be a topic every single month. But that brings us to the end of our articles for this month. But the other thing that we like to do, Malcolm, is do a little comparison of policies, procedures, laws between our state and Alabama, what we do, and our guest home state, yours being in South Carolina. And it's just a little bit of a contrast because Alabama does things the way Alabama does things. And we like to learn from our guests how your state does it. And the first thing I want to talk about is attorney's fees. And I guess what I'll ask you is, are they set by law in the state codes, or how do you determine the fees? Do you earn fees only at the end of your case. Talk to us a little bit about that.
Well, I guess there are two stages of any workers' compensation claim where an attorney could charge a fee. In a denied case that is then found compensable or deemed compensable or resolved or accepted eventually because of the work done by the attorney, and there is past due compensation due. The claim has not come to an end yet, but compensation has been delayed and started, then an attorney can charge a fee up to a 1/3, 33 1/3% of the past due benefits that the claimant receives. That's not usual. I mean, those are more of the outlier type situations. The more common situation is a claim, it comes to a conclusion and the attorney files his proper form. It's called a Form 61, where you set forth your costs and your attorney's fees, and by regulation, not statute, attorneys, practitioners are allowed to charge up to 1/3 of the recovery.
Well, it is, again, Alabama it lags behind. We have a statutory set at 15%. And if we lose the case, of course, there's no recovery. But if we win the case, we're able to recover our reasonable court costs and fees, or excuse me, expenses, as well as a 15%. We make sure, obviously, in our first conversation, when we're hopefully going to be hired by the new caller, that we set all of that out, not only in our communications to them, but also obviously in the contract that we ask them to review and to sign. In our cases, again, we can either go through the state ombudsman program to have them approved, and they've changed those procedures during the pandemic, or we go through our state circuit court judges and have what we call a benefits review, a best interest hearing. And it's the same as a benefits review conference with an ombudsman. The judge just wants to make sure that the injured worker knows the settlement terms of the case and it meets the criteria of the law, and that the injured worker understands all of the criteria. Because the last thing you want is to get finished 3 months later, you didn't tell me that my medical care is no longer going to be covered. Well, we covered it, and that's why we have these hearings. Malcolm, there's two more things I want to talk about, but kind of goes in line with attorneys and attorneys' fees. Can non-attorneys represent injured claimants in South Carolina for work comp benefits?
No, the practice before the South Carolina Workers' Compensation Commission is considered to be the practice of law. Now, if you're pro se, you certainly can represent yourself without assistance of a lawyer. But if you are an individual representing at a hearing a claimant, if you are not a licensed member of the bar, then that constitutes barristry in the unauthorized practice of law and is punishable by criminal penalty.
Yeah. And I believe it's the exact same in Alabama. And
right.
what is always curious to me, and this is not a proper analogy, is in the federal system for Social Security, you don't have to be a licensed lawyer to be a representative of individuals in Social Security disability claims. We do that kind of work at our firm as well. But sometimes we come across folks, if we actually have in-person hearings, which obviously it's been quite a while for those, you'll see individuals who are not licensed attorneys, but they very much know what they're doing from a representative standpoint. Last comparison before we get you out of here for this month's episode of Work Comp Today are appeals. There's many different layers of appeals. Our appeals can be within the circuit court level, or they can go up to either our Court of Civil Appeals, or they can go to the Supreme Court. They're just all different types depending on what stage of the litigation that you're in. And obviously we can be remanded back to the circuit court depending on instructions. Do you have appeals through your administrative system?
We do. After the determination by the hearing commissioner, either party, of course, has the right to appeal. And that appeal is, for those non-practitioners who are listening, is a de novo appeal, meaning that the appellate panel of the Workers' Compensation Commission that would consist of 3 workers' compensation commissioners or judges, not consisting on that 3-member panel of the one that heard the case, obviously, but those 3 can reverse, affirm, reverse in part. They can do whatever they want with the case on appeal, but there is no new testimony offered, and the only new evidence that can be placed in the record would be after discovered evidence, meaning evidence discovered after the hearing. But there's a very strict and narrow criteria of what constitutes after discovered evidence. So that's the first level of appeal from the hearing commissioner's decision and order, is to a 3-member panel of workers' compensation judges in Columbia at the South Carolina Workers' Compensation Commission headquarters. Those appeals are generally heard within 3 to 4 months from filing. And if an aggrieved party decides that they got it wrong also, or they got reversed and the hearing commissioner got it right, then the next level of appeal is to the South Carolina Court of Appeals. And those appeals must be heard and disposed of by the South Carolina Court of Appeals. They do not have a choice in hearing and adjudicating those cases. In the event that someone wants to appeal a decision from the Court of Appeals, then perhaps, like in Alabama, you can file a petition and ask the state Supreme Court to review the Court of Appeals decision, and that is optional. The Supreme Court decides which cases it wants to hear or does not hear.
You know, from a practitioner standpoint, sometimes it becomes a strategy decision. Depending on which judge you have, depending on who's opposing counsel, it could be used as a sword or a shield, the appeal process. And nobody wants to make any bad law, but at the same time, we may have judges who just during their private practice time period had no exposure to work comp cases, but now they're being thrown into pretty significant work comp or sometimes complicated fact patterns. And so we have to do a lot of education, a lot of brief writing that sets out what the Alabama laws do and don't do. So it really is it's a lot of legwork on the circuit court level sometimes.
Yep.
That's not all the time, but we certainly don't have the luxury of a lot of judges having experience in the work comp world.
Right. Well, that's, I guess, many states, South Carolina and North Carolina, employ the industrial commissions, what it used to be called, and now the Workers' Compensation Commission system, to hear cases at the initial hearing level. And those commissioners or judges, at least in South Carolina, and I believe North Carolina is the same, do not have to be lawyers. And in fact, roughly half of our commission now consists of non-lawyers, and the other half being lawyers that worked exclusively on the defense side. The governor is the one who appoints workers' compensation commissioners. They have to be approved with the advice and consent of the South Carolina Senate. But we've had a string of Republican governors now for well over 20 years. And so they tend to a certain type of commissioner that they're looking for.
Sure. We'll pause the political talk and our discussion for this month. We'll pause that for now. I want to thank you, Malcolm, for spending some time with me today and going through our monthly program of Work Comp Today.
You're very welcome, Bernard, and I enjoyed it, and I appreciate the invite.
Absolutely. We're so glad you had a little bit of time, particularly on the eve of our annual conference that's coming up this weekend for the Workers' Injury Law and Advocacy Group. And thank you for your continued leadership. I hope to see you in person in the next couple of days. And thank you again.
You're very welcome. And I look forward to seeing you in a couple of days down in Florida.
Very good. Well, guys, this will conclude this month's monthly episode of Work Comp Today. Dave wants to continue to change the topic. We'll have to readdress that when he comes back next month. But we've got our buddy Lindsay Simmons, who practices in South Alabama, Fairhope with King Simmons. They have offices in different parts of the state. The date is October 28th. And we always look forward to talking with Lindsay. And guys, that'll do it for now. But please continue to be patient with this pandemic. Do what's right for you and your family, and just be careful out there. We will catch you